Good evening. I'm Michael Hernandez,
I'm Brittany Vela.
and in tonight's cast of BVE, the 14th Amendment violated by public schools.
Brown v. Board of Education, now acknowledged as one of the greatest Supreme Court decisions of the 20th century, anonymously held that the racial segregation of children in public schools violated the Equal Protection Clause of the 14th Amendment. Although the decision did not succeed in fully desegregating public education in the United States, it put the Constitution on the side of racial equality and galvanized the nascent civil rights movement into a full revolution.
Now to our special speaker, Linda Brown, daughter of Oliver Brown.
Hi, I'm Linda Brown. Even though there was an elementary school close to my house, my sister and I had to go to an all-black school much further away. We had to get up really early and walk, then take the bus to the Monroe School in Topeka, Kansas. We weren't allowed to go to the summer school that was closer to us because it was for white children only. Even though some schools in my community were open to everybody, a Kansas law allowed the Board of Education of Topeka to establish segregated elementary schools like the all-white summer school in my neighborhood and the all-black Monroe School that I had to attend. With the help of our lawyer, Thurgood Marshall, my family and I sued the Board of Education. Children in other states had the same problem as we did. So when we took our case to the Supreme Court of the United States, the court combined our cases. The court struck down the laws allowing segregated schools. The justices that said separate is not equal, they ruled that laws segregated students by race were unconstitutional.
Now back to this. Large portions of the United States had racial segregated schools made legal by Plessy v. Ferguson, which held that segregated public facilities were constitutional so long as the black and white facilities were equal to each other. However, by the mid-20th century, civil rights groups set up legal and political challenges to racial segregation. NAACP lawyers brought class action lawsuits on behalf of black school children and their families in Kansas, South Carolina, Virginia, and Delaware, seeking court order to compel school districts to let black students attend white public schools. Now for our next public speaker, Chief Justice Earl Warren.
My name is Earl Warren. I am the Chief Justice of the United States of the case of Brown v. Board of Education. After hearing the case, all 9 of us decided that segregation was not legal. Here is a section of the court's decision in the words of some 8th graders. Education is the key to good citizenship. In school, children learn cultural values, prepare for careers, and to be successful in life. It is doubtful that any child can succeed in life if denied education. Education is the right that must be made available to all equal terms. Separate schools are unequal.
Very interesting story, Chief Warren. One of these class actions, Brown v. Board of Education, was filed against the Topeka, Kansas School Board by Representative Plaintiff Oliver Brown, parent of one of the children denied access to Topeka's white schools. Brown claimed that Topeka's racial segregation violated the Constitution's Equal Protection Clause because the city's black and white schools were not equal to each other and never could be.
The federal district court dismissed his claim, ruling that segregated public schools were substantially equal enough to be constitutional under the Plessy Doctrine. Brown appealed to the Supreme Court, which consolidated and then reviewed all the school segregation actions. Together, Thurgood Marshall, who would be appointed the first black justice of the court, was chief counsel for the plaintiffs. This just in, the law has been approved for equal education. Now black and white students can go to school together. That is all for tonight.